All right. So this panel is to talk about making tokenization accessible by everyone. Right now, that could mean multiple things, and we'll go into, what that means later. But right now, kind of people entering into the blockchain space, trying to do tokenization, it's kind of a long and expensive process. And over the next, year or two, I think you'll start seeing people being able to tokenize more easily, finding lawyers that are cheaper, more efficient, finding technology that allows, them to tokenize even without developers. But before that can all happen, there's some fundamental things that, have to happen in the industry and some issues that have to be addressed. So this panel will talk about that. Let's do some short self-intros. I guess people have met most of the people here already, but let's do really short self-intros just so everyone gets a refresher of who everyone is. Carol, you want to start?
So other than having a 28-year-old son, who happens to be a Episcopalian priest, I happen to be a preacher's daughter, so I'm sandwich generation. I'm a fintech, regtech lawyer of definitely more than 20 years. I've been in the banking regulatory space for a lot longer than that. And as I said earlier, have been involved 2 feet totally into the world of digital currencies, digital assets since 2008.
Hi, I'm Stephen Rutenberg from Polsinelli. I spoke before about the loan market, which is an area that I've focused on, which is similar to crypto on the edge of securities law. And though I'm not the parent or the child of an Episcopal priest or any priest, I do think that in as much as we need to think about the legal issues in crypto, the moral, ethical, and philosophical issues of what type of society we want this to build are probably almost as important. So I do think we should probably have a panel of theologians here as well.
Well, it is theology that dictates a great deal of what happens in this area.
I'm going to take the Eastern philosophy approach. Josh Lawler, I'm an equity partner at Zuber, Lawler, and Duca. I've been practicing securities law for at least 25 years. I've been practicing IP for probably about 15, so this kind of fell out of the sky and landed on my head. Advising a bunch of clients on doing, we'll call them JCOs, I guess that's the term, to Jobs Act token offering, something like that, legally as securities.
I've had some clients that need priests. My name's Bob Cornish. I'm from the Washington, D.C. office of Wilson Elser. I'm a securities litigation and enforcement attorney, but I've also served in-house as a general counsel for an investment management firm and a family office. I'm also a member of the Wyoming Blockchain Coalition. Shame on that 2:30 panel for mocking Wyoming. Very proud of what we've done there. I counsel people in the ICO space on fund formation, securities compliance, and doing business in Wyoming. I am a proud member of the Wyoming Bar, 15 years. So.
I'm just saying, I think Wyoming's population is 500,000 if you Google it.
And there's 1 million cows. So at a previous panel that I did, I showed a picture of a cow. And I do think just on that, I think in defense of Wyoming and what we're going to get onto some of the tokenization, it's really to separate what we're talking about in terms of the friendliness of a law of a location, where I think what Wyoming doing is really important, and trying to raise money avoiding securities law, where I think Wyoming may be a model, but it's not a place yet where you can sell.
Yeah, they're stepping mat to the next law. Yeah. I'm just kidding. I'm Jor Law. I'm a corporate and securities attorney.
They put some cows on the blockchain last week, by the way.
I'm a corporate securities attorney by training. I'm transitioning out of that and just focusing more on the business interests that I have in the space. Within the space, I've got a company called Prime Trust. They do trust and custodial services within the space. I've got a company called Verify Investor that does accredited investor verification in a space recently acquired by T0, the secondary exchange. And I've been taking a very front and center role in helping build out tokenization ecosystems and technology to allow essentially people to tokenize without needing a developer. So that's what I'm working on. Let's jump into it. there was debate among, the panelists about what we talk about, what does tokenization really mean? What does accessible by everyone really mean? Stephen, why don't you talk, about, I think what we'll probably focus a little bit more on today, which is tokenization of like securities versus, just tokenization.
Thank you. And I think we need to separate when we're talking about tokenization, just on the security side. Meaning when we're talking about that, I mean using a token as a fundraising or connected to an asset to raise money. About whether you're talking about tokenization for everyone, that every asset should be able to be tokenized if it makes sense. And the question is, does it really add value to tokenize everything at this point? And whether or not the purchase of these tokens should be open to everyone. And I think the question kind of leaves that open. And I'm of the view that we've done pretty well with the startup market and whatever else that did on the communication side with the internet, not being open to non-accredited investors, and we got very high valuations. And do we really want this industry, if we think it's going to be that revolutionary, to be the one that breaks down the barriers and being sold to everyone? That doesn't mean we shouldn't possibly change the definition of accredited investor to include people who have other forms of sophistication. But in general, I think the SEC is trying, among other things, is trying to tell us, this industry is trying to sell to unsophisticated investors, and that everyone probably shouldn't be here at this stage yet. I know that's not the popular view is probably more that it should be sold, that we should be able to sell tokens to everyone, but until you have some sort of disclosure, or if it's not gotten through a system, it's my view that it shouldn't, unless it's better for our industry to limit it to accredited investors, or even if we change that definition a bit.
Well, I think the issue we've got to deal with here is, what are we talking about when we say token? Are we talking about what is clearly a securities instrument, or is there room for this concept of a utility token that might be regulated in a different fashion? And I think that's where, as I said earlier in my comments, that everybody says my token was a utility token to try to avoid coming under the securities laws. But if you don't come under the securities laws, you actually come under something else, and people are not talking about that. And what we miss in this whole conversation is we have a whole system of laws, at least in the United States, that are intended to protect the consumer and the consumer's money. So we protect it through the securities laws with securities. We protect customer money through, in a bank, through the laws that govern the banks. If you put it into insurance companies or insurance vehicles, it's protected under those laws. If you give it to a money transmitter to send it somewhere for you, it's protected under those laws. Utility tokens have not gotten as much focus from a pure utility standpoint, but if you think about everybody always uses Chuck E. Cheese tokens as an example of what a utility token is that hasn't historically been heavily regulated, but we do have a whole system for regulating what we call prepaid access. And if we're going to take things out of being a security, we're going to probably end up in that category. But again, there hasn't been a lot of discussion, but that is a step to potentially making this accessible without all of the mess that goes around a security. But it's still going to bring with it a certain level of regulation.
Yeah, I think that's actually exactly right. And two words that we haven't really heard too much today, which isn't surprising because it's a lot of room full of lawyers and not necessarily as much developers, but is use case. The fact of the matter is that we kind of have the tail wagging the dog here a little bit. The reason that these things were developed in the first place is because they do serve some type of utilitarian function now. People figured out somewhere along the line that they could use kind of supply and demand dynamics and valuation to raise money on that in a new and different and, at the time, seemingly easier way. And that's kind of put us along the path that we've gone on. But in terms of figuring out what rules should apply, it's really a question of figuring out what the use case is and then being true to that use case. And that use case might be something that's closer to a Chuck E. Cheese token, in which case it wasn't used for capital formation, because that's kind of the hallmark, really. Or it might be something where it's cows on the blockchain, in which case it might be commodity oriented. Or, it might be something where, no, really, like the guys who were doing the real estate earlier today, it's truly a security, and it's providing something that's intended solely for the purpose of generating a capital gain or generating income. But probably getting that categorization figured out is a good first step.
There's actually some interesting stuff going on in Malta with regarding the categorization, as well as Switzerland. As you know, Switzerland has 3 categories of these things. Malta seems to be taking a different tact because they realize that you really can't categorize the stuff. And they're essentially going to have a panel of people deciding whether something's utility or not. I'm not sure how that works in terms of providing regulatory regularity, so to speak, but in terms of providing guidance, you have a real legal issue in terms of how you manage subjective and objective regulation. It's just an interesting area.
I think Carol made a really good point, and I don't know how far you're willing to take that, which is that it's really, regardless of what it's classified as, if you're taking consumer money, the U.S. government has always found a way to regulate it. I mean, foreign exchange is technically not regulated, but they've managed to basically shut that down. I mean, Chuck E. Cheese isn't regulated because nobody really lost money with their Chuck E. Cheese and nobody really invested in it.
You haven't gone there with my kids, clearly.
Well, I don't think you haven't had no homeless person on the street have seen a sign said I lost all my money to Chuck E. Cheese. But the question is, I'm kind of asking you, would you think we should take it this far that the market should self-regulate and just not sell to consumers, only sell to industry players for a utility token?
Well, I think that defeats a lot of the promise that the tokens offer, which is, and I don't want to get into too much of that theology or philosophy or whatever we're talking about, but of democratizing access to democratizing investments, both from the standpoint of the investor as well as from the company standpoint. So tokenizations, ICOs, STOs offer a great deal of promise for companies that have been frozen out historically from the markets, from traditional financing sources. That, if you're not in Silicon Valley or you're not in the men's club to gain access to capital for a venture, you come up. You're not going to get that funding. Now you can go directly to market. Likewise, there are lots of people who don't get that first crack at the promising new young company that's going to become the next Google or Amazon, because it's within, again, that small circle of folks. So it's working from both directions.
Yeah.
But I think it's necessary as we go further is to really dig into the use case and figure out what that use case is and what the appropriate regulation is around it. Unfortunately, with the expansion of the ICO market last year, we didn't have time to take a breath and think about that.
Yeah, absolutely. And I mean, one of the great kind of oxymorons here, and one of the reasons why it's not really practical to just limit it to accredited investors, is that a lot of the use cases involve peer-to-peer transactions. So the tokens at some point have to go on to being either not securities, which I don't like thinking about because it just is too difficult to keep your head straight, or unrestricted securities, which makes Reg A plus Tier 2 extremely valuable if the SEC will finally qualify a document so people can use it, because it can let you do a widespread sale to non-accredited investors that they can then trade peer-to-peer, given on an ATS would be great. And I think the trade-off for that is continuing disclosure, which I think is appropriate, and you need that in terms of protecting the public. But you can't limit it to accredited investors because the whole thing just doesn't work.
Yeah, I mean, this is, the presentation I gave this morning, kind of touched upon this, this idea that, people are selling to accredited investors as opposed to the public, and whether that was right and whether that was appropriate or not. And, the truth is, we've got to figure out, what to do. I do agree with Stephen that, certain protections need to be given, and the system isn't that far broken. I do disagree that blockchain means that, everyone has a right to invest. I think, it allows it, but there's nothing today that says that there's nothing special about blockchain technology that says, oh, okay, now it's here, finally the common people can invest. Like if that was something that we care about, then we should be able to do that even without blockchain, right? But it does kind of,
Just as an aside, there are fewer public companies now than there were 10 years ago. And the very regulations that people are saying should be, imposed on this industry are the ones that are stifling capital formation. How do you balance that?
Well, sorry, go. No, finish. Sorry.
No, that's all.
No, I mean, not to sound like the angry pastor, but the industry here should, in some ways, be ashamed of itself, because we kind of had this opportunity to sell these ICO tokens to the public, and I'm not talking about the ones that are securities, and 90% of them were basically something that a sophisticated investor would not buy. I mean, it's one thing to open up an opportunity to public investors. It's another thing to do something that you would never recommend any of your relatives to buy. And I think in some ways the market has
Call
to
that
like.
the Ford Pinto syndrome.
except for the sophisticated investors did buy, and then they made a killing when they flipped it.
Well, because they probably had inside information. That's not.
On the coin.
Well,
Pinto.
and I think the jury is out as to what will happen to those.
Yeah, I think there's a target, because I mean, it's not those people who first bought, it's Main Street who bought afterwards.
Yeah.
And that's the big problem, is you have the giant investor who gets a 95% effective discount, holds it for a month, it's on an exchange, and then sells it to the guy in Indiana, nothing against Indiana, or the guy in Wyoming.
So we should even. I mean, that shouldn't make us feel better that we made money before screwing.
Well, no,
over
but the
public.
point is, that's why the SEC has to jump in, because the Main Street investor is getting absolutely killed.
So let's move on to something else. Do we want to go over the regulations to watch still, or do we want to skip that, since it's been talked about a lot today?
Well, I think I would take it, I would look at it from a different perspective, not regulations necessarily to watch, but make sure we understand the regulations that actually do apply, even though a lot of people have tried to say, oh, this is new technology, these are new things that are happening, and laws don't apply. I think that we do have regulation coming in certain areas, and certainly we could delve on that, but I think we have to understand what's out there already, and I know one of the areas of confusion is consumer protection.
Yeah, so let's spend some time on that. Josh, Stephen, is there anything you want to say about SEC or securities laws that you think would not be repetitive from today's
We'd be here all
discussions?
day, but not for tokenization.
Yeah. Bob, CFTC?
I think there's going to be a lot going on in terms of physical commodities and the use of the blockchain and how regulations are going to be framed. Already in the ag industry, you're seeing a lot of implementation, and the CFTC is kind of gearing up for it. So you may well see a very different commodities and futures markets if that's an area that you're involved in.
Carol, Bob, FinCEN, money transmission, including AML, KYC?
Well, I unfortunately have not been here all day, and I don't know whether the issue of FinCEN regulation has been fully discussed. I think the important piece is that when FinCEN said to Senator Wyden, any coder, anybody coding who then sells currency or a token for fiat or other things of value needs to register as a money service business. If an ICO, today is May 24th, if someone did an ICO, is it November 24th, I think, before November 24th, is not yet registered with FinCEN, they are in violation of federal law right now. You have 180 days to register. FinCEN, I have been going to FinCEN and asking questions, and FinCEN has told me that it will be the day that you issue the tokens that you'll be marked for becoming a money service business. You have 180 days from that date. If you don't register, you're then in violation of 18 U.S.C. 1960, which is a federal criminal statute that says failure to be registered. If you are required to be registered, is a federal crime. You can go to jail for 5 years. It also becomes a predicate offense for a money laundering offense under 18 U.S.C. 1956. And from there, it can be used as a basis to seize assets. So if you want a path to getting at the proceeds of an ICO, that's the path. So that's one thing to watch. That will come not in the form of regulation, but come in the form of enforcement action and DOJ action.
I think in the AML KYC space, there's going to be a lot of movement in the banking regulations. I was at a meeting at the FDIC a couple weeks ago on financial innovation, And the regulators there are already gearing up for the ability of banks to be more involved in the cryptocurrency area. What that means, I think, is you're going to see increased emphasis on how to complete SARs, which we haven't talked about today, which are suspicious activity reports. You know, if you're a financial institution, you have to submit one of these if you see something that looks somewhat suspicious, a red flag that shows money laundering, illicit activity, so on and so forth. How are all those things going to fit into this area as we develop this nascent world of regulation?
If I could, I do a great deal of work in this area, and I've been working with crypto exchanges for several years now in filing SARs because they are money service businesses and they are subject to this requirement. FinCEN and law enforcement community are uniformly in agreement that the SARs filed by the crypto community actually are among the best SARs that they see because it's data-driven and they provide a great deal of information to them. In terms of the banks, we're going through yet another wave. This is probably, I think, the third sort of purge that we've seen since the crypto space really heated up. The banks have become, again, we were just sort of getting to a thawing point, and then suddenly the banks have all pulled back. I think not the least of which is because of announcements like today, the Bloomberg story saying the CFTC has begun a criminal investigation, or DOJ in connection with, or in conjunction with CFTC. So those types of things, when you see the banks starting to pull back, is always a warning sign that something big is something's coming that's probably pretty big, and that's what we've been experiencing for the last several months. So whether we can get to some thawing points, I've seen some technology just this last week that I think, if it can be deployed in the right kind of way, will go a long way to helping the banks get more comfortable in their AML compliance regimes, and maybe where they get to the point that they start to be a little bit more willing to work both with companies and with customers who are involved in this area.
I mean, I don't know how practical it is, but I've seen some companies which appear to be able to track the nefarious activities on the blockchain without identity. And so far, we've connected KYC with identity. And I'm wondering if both, I mean, what they claim to be able to do is, without knowing who the person is, by kind of knowing who they hung out with, able to run a report and trace things back. And I'm wondering if, from your experience, if that's a potential way that this market to go, both that people could have to file SARS reports without even knowing who the party is, or down the road possibly is there a hope that we can keep the anonymity of crypto while being able to figure out the nefarious activity without knowing who the person is?
That flies totally in the face of
everything.
All of the AML compliance regime is the anonymity issue, and that's been the big rub. But there are products, companies like Chainalysis that are out there that have been able to have been mapping the blockchain and now moving to mapping the Ethereum blockchain, Monero, Dash, etc. I've seen tools that will allow really agnostic to the blockchain, which will facilitate even greater mapping going on. Data points are critical, so Chainalysis, for example, has been able to build out names that match wallets on the blockchain because they did the work out at Mt. Gox, they did Silk Road, they were instrumental in the takedown of Alpha Bay and also BTCE.
Yep. So, I mean, go ahead, Jor.
No, I was just going to say, staying on the AML KYC topic, trying to get practical, I think there's a lot of folks that are out there kind of doing ICOs, and they're not banks, they're not financial institutions, they're not really, they're not going to have a BSA expert internally, right? So, practically, what advice or what insights can we give them to understand how AML KYC is done? Understanding, it's easy for a lawyer to say, oh, you should do this, this, and this, and this, but, what tools exist for them to do this? And like you said, don't trust a third party to make the AML KYC decisions. I think a lot of people that are doing ICOs think that, oh, I'm just going to use this service and they're going to tell me pass, fail, without realizing that they have to set the screens themselves and figure out, unless you're truly trusting a third party, like because it's like some financial institutions or whatever. But if they're using software like Identity Mine on FIDO, et cetera, they actually have to choose the screens themselves and then know what screen to choose and how to process the information when they get flagged as a maybe. which happens like 60% of the time, not like 2% of the time.
You'd be surprised how many people have never seen the FinCEN website, you know, on the section on the Treasury's website. I mean, that's for better or for worse, that's actually a really good place to start and just read what your obligations are. I mean, if you read that, you should be somewhat shaken into saying, I better call somebody who knows something about this.
Right, and I think that that's the key. And there is an evolution of technology, and I think ultimately there is a technology solve on that, but it's not here yet. For the moment, we're kind of doing it the way everybody used to do it when, you know, this asset class didn't exist in the first place. And that's what we have to do. And for what it's worth, there's really good reasons for it in some ways. I don't know about the states each having their own rules, but you know, I personally would prefer not to be funding terrorism also. So that's kind of a good thing. I do think, and I've seen 4 or 5 different companies attacking this from different directions. There is a way to do it that's probably stitching something into the token, or alternatively having each person have their own equivalent of a medical records type of scenario where you don't necessarily have to expose anything unless, you know, you're flagged as being a red flag, and then it exposes your identity.
Okay, so I started doing this work before 9/11, which is always a line of demarcation because that's when the whole AML regime got much tougher. A couple of points that are very important. What people are doing for KYC now in the context of ICOs is really looking to gather information to determine whether somebody's in the United States or not in the United States, whether they're accredited investors or not for the SEC's purposes, and for OFAC purposes. None of those are really AML. AML is, do we know whether this person has a background as being a money launderer? Can we then track the activity and the purchasing patterns and so on to have some sense as to whether they are possibly laundering money or possibly facilitating terrorist financing? There's a whole, this is, we can just start to even touch on this. So I developed an AML compliance boot camp for virtual currency companies in 2015, which was before its time. And we're working on bringing an ICO one out now because there is this problem. Now, the other thing, going back to this comment about registering as a money service business, this is the thing that's really important. If you've done an ICO, you now, under FinCEN rules, until you get further clarification, are considered to be a money service business, and you are expected to have an AML compliance program. And that AML compliance program needs to be adequate, cover everything it needs to be. It needs to be implemented, and it needs to be effective. And if you cannot show that that's effective in detecting potential criminal abuse of your system, of your ICO, and there's a lot of definitional issues that need to be worked through here, you don't have an effective program, and that in and of itself is a violation of law.
Yeah, for those of you that are planning ICOs, you know, definitely consult with someone to figure out what, you know, AML KYC regime you need to run. You know, don't think it's easy. If you go through the Reddits, if you go through the Telegrams, you know, AML KYC is probably the #1 thing that causes hiccups in the offering process. It's just, you know, everyone thinks it's this fast automated thing. In reality, there's a lot of manual labor that's involved because, you know, out of you know, like 10,000, you know, investors, a large percentage of them are going to get flagged for manual review. So just be ready for that. It's a mistake I keep seeing companies make over and over, and they get hit with this volume that they don't know what to do with because they haven't been prepared for it.
Well, and there's another important point that even if you're not subject to being a money service business and having to put an AML compliance program into place, the federal criminal statutes for money laundering still apply. And those statutes say you're not supposed to be basically involved in handling the proceeds of illegal activity. So if you are accepting what are the proceeds of illegal activity in the sale of a token, and you don't know it, you haven't taken steps to provide it, that's a whole other path that the Department of Justice, federal prosecutors can pursue.
A fun reminder in that vein, the Foreign Corrupt Practices Act, yeah, the liability goes all the way down the chain, all the way down the chain. So if you are involved in money laundering or some illicit activity that involves a governmental entity and you don't know about it, you are going to be on the hook, not only for criminal penalties, but for financial penalties as well. There's no reason not to comply with all of this. The one thing I did want to add was, we haven't talked about people working with clients overseas. There are FinCEN jurisdictions where AML and those provisions aren't even recognized in the United States, and those change somewhat regularly, correct?
I guess what you're saying is if you're selling a token into other countries, to what extent do you need to be compliant with the regime?
Yeah.
Well, for example, I was just seeing Serbia yesterday or last week was not deemed to be a FinCEN compliant jurisdiction.
Oh, yeah.
And suddenly you got a call from a client in Zagreb who wants to do an ICO. What do you do?
Yeah, no, that's an issue. So is, so are some of the folks that have gone to Caymans and, incorporated in Caymans, and they've realized that the AML KYC regime there is pretty tough also.
So what that means from a practical standpoint is if you are the token seller, that you need to do an enhanced level of due diligence with respect to the transactions that are flowing through those locations. That's what FinCEN designation means, is basically up your KYC, well, up your KYC, your trust for due diligence generally, and you also have to make sure your suspicious activity monitoring is enhanced.
Yeah, let's switch topics. I'm going to skip a whole bunch of stuff because we've got about 8 minutes left. A lot of people today have talked about tokenization of securities. And specifically, you've heard a lot about, tokenization of equity, that's the next big thing, that's the next big wave, right? You're going to hear that repeatedly at every conference you go to. It's not quite so simple. Yes, that is the next big wave. I also do believe that. But Josh and Stephen, maybe you can kind of start us off on the impact of tokenization on like corporate legal events, right? Equity acts a certain way, and right now blockchain architecture acts a certain way. They don't necessarily play nice together.
They will. I think the trend is going to be that your tokens are your equity. And there's a whole variety of reasons for that, not the least of which is getting away from some of the scarefest that we just heard in terms of KYC AML, because if everything is going through a FINRA certified broker-dealer / exchange, there's some exemptions that apply that make things a little bit easier. But in terms of what's happening with the corporate events, if you do a merger right now, we heard somebody else mention the idea that the large companies don't know what to make of the liability on blockchain, and nobody really knows what value there is to administering a blockchain. But whatever that is, you're pulling it along with you if you merge that company into yourself. If the tokens are actually equity instead, and you can do this in Delaware and you can do this in Wyoming. I actually just read the Wyoming corporate code last week. That was fun.
That's revised, by the way.
It was lovely. But in any case, you can now put your stock ledger onto a blockchain. And once you're putting your stock ledger onto a blockchain, given there's a few practical issues, but we're fixing those, then at that point your stock can be your token, which is also really nice because that means that you're going to be able to have it on an ATS because it's no longer going to fall outside the definition of eligible security. It means that it can be used for Reg A Plus for the same reason because it's not going to fall outside the definition of eligible security. By the way, those definitions were written before the asset class existed, so maybe they get amended, maybe they don't, but this fixes it. Now, once it's stock, we know exactly what to do with it from a merger and acquisition perspective. There's a lot of developed law on the various situations where that works. I also am going to do a shout out for Snap for somebody finally coming out with a truly non-voting whatsoever share of common stock, because that makes life a lot easier in terms of putting your tokens on common stock. You don't have to worry about the vote.
I completely echo what you said and what one of the panels earlier this morning said. If you want to do a security token, which basically you can just think of it as your ledger is on a blockchain instead of a paper ledger, the laws are basically there. I think that it's not like this is going to be. I don't think it's much cheaper than a regular Reg A offering, but it shouldn't be much more expensive other than just keeping some other things in mind. The same with a Reg D offering, and we have all of these exemptions, and it works to do it in crypto. I think the gating item is, does it offer enough advantages to an issuer to make sense to go through the brain damage of it at this point. And I don't think that one's the legally hard one. I think kind of we have the utility side of it, which is legally really hard, but everyone wants to do it. And then we have the security side where the laws work. It's just a question of making the business case for it and making it make sense from a business perspective.
Well, we think they work because I'm not aware of anybody doing a really full-blown S1 on a stock exchange listing where they don't have a transfer agent for a new issue and they're using the blockchain.
No, that's actually a really great point. And you know, sometimes I refer to distributed ledger technology as the great disintermediator, including the transfer agent. And that's a whole different discussion about the legacy systems and participants not wanting to lose kind of what they're doing. But at the same time, the piece of it that really is the rub becomes that use case again, because a peer-to-peer token system doesn't really work so well in terms of needing to go through brokers and dealers and transfer agents and everything else. You just want to have, you know, Bob be able to send the token to Carol.
Yeah, there's definitely layers to think about this stuff. You know, anytime you take equity and you just tokenize it and you go raise money, you immediately at least have kind of, you know, disclaimer issues and things like that you didn't otherwise have yet, you know, to talk about, you know, risk factors with respect to tokenization. But there are certain things that you can do under corporate law now that you can't easily do through token architecture, right? If you're looking at ERC20 token, for example, and you issue out a boatload of tokens, and then someone comes around and wants to buy your equity, you know, 100% of your equity for in a stock transaction, right? Well, what happens to like the 5% of people that lost their private keys? They can't transfer them, right? So these are things where, like, you know, under Delaware law, under Wyoming law, under most laws, yes, you can do a equity purchase, but you can't actually affect that on the Ethereum network if someone's lost their keys. There are issues around it, you know, ways around these types of things, but you know, there are things that I think, you know, people have to think about, and I think lawyers are drafting in this space. For you lawyers in the room, you really have to think about what could happen in the space and make sure that your legal language allows your client to have certain amount of flexibility to adapt to blockchain architecture and infrastructure limitations, because that will all be pretty important, because honestly, I don't think anyone knows the limitations of you know, where they've missed something yet. You know, that will come out in the next few years. There's a question back there.
Right to Q&A.
Hi. Okay, hi. First of all, thank you very much. This is fascinating. If I had to phrase the title of this panel as a question, it might be, how can we make tokenization accessible by everyone? And the answer I'm getting is we can't. The burden in terms of the cost, the time, the expertise required really sounds like this is, you know, this is for big business. These are big clients coming to big firms. But what I'm going to ask, though, real quick, is if everybody could switch their hats and answer that about how we can. How are you wrong about the onus of regulation right now if it turns out that tokenization really can maybe not trickle down, but start from the bottom up and reach everyone? How does that happen? What paths forward do you see?
No, I don't think it's that you can't. You know, I've been working with a number of companies that are trying to do this, right? There are certain companies now, and they've got demos out already. You can go to the GitHub, it's active. You can go through, answer a series of questions, assuming you know the answer, and within 5 minutes, you'll have a live token on Ethereum mainnet. No developer whatsoever, right? That's something that ordinarily would have taken you a few months after finding a developer that was willing to work with you and charge you arm and a leg for it. And right now, there's frankly just not enough service providers in the space that know what they're doing, but over a period of time, that will definitely increase. And people are out there building networks so that while you're there creating your security token in a heartbeat, you can select your AML KYC provider, you could select your legal service providers, et cetera, so that, you know, maybe it won't be quite that fast actually. It'll still be a lot faster, a lot cheaper than
I'm
it is
going to
today.
take that from a different direction, though, to try to answer the question. You know, not like I said before, we kind of have a little bit the tail wagging the dog here. If people aren't using this for capital formation, it's not a restricted transaction, and it's questionable whether you would call the token a security in the first place, but it's just too confusing to say it is here and it isn't there. So, if you're not using it to raise money for your enterprise, people aren't looking at it as something where it's going to be an investment that's going to increase in value. Tokens can have a ton of wonderful use cases. There's many of them. The creativity is quite astounding, actually. It's just the fact that they're being used in a particular way where, rightly, in fact, there's a lot of good reasons why regulation needs to be there. But that doesn't mean that tokens forever are limited. It just means as a financial instrument, there's some limitations.
And I'm gonna take it from a slightly different perspective as well. I mean, in terms of tokens that are securities, I do think what Carol said before. I mean, there will be some some trickling down. That the venture capital market will be open to a broader group of people. But what's really at the heart of your question, which I do think there is something else happening here, in which we're, for the first time in hundreds of years, really examining, maybe we did it in 1919 and it didn't go that well, but we're examining what it is to own something, what is property, whether it's happening with artificial intelligence, whether it's happening with the rights to my data on the internet, whether it's rights to the comments I make, should I get some reward for that? There is something interesting going on, and I think this, even if it's had its excesses so far, the ICOs and of the last 2 years has gotten people to think about what does it mean to own something? What does it mean to own something in a share of a company? And I think one of the exciting things about this market, in addition to abilities to raise money and abilities to do things more efficiently, is I think it's opening up a discussion about what each person owns. And where it goes for that, I don't know legally, but we need to think that through, because there's clearly a desire for that.
It's a new industry. Things are a little bit longer and more expensive now. Once they get figured out, everyone's fees are coming down. Everything becomes faster. Guarantee it.
And I think you go back to the technology, as you said earlier, we are seeing increasing products, and security is one of them that's going to facilitate more asset classes being accessible to more people in more places around the world.
We have to think about what access really means. If somebody can issue a token virtually instantly from a laptop computer, what is that person's obligation to make disclosures to the world about what they're actually doing? Do we want people to be able to do that very quickly and raise capital and not have that disclosure and let people do what they do and assume the risk of investing in these things? Or do we balance that with perhaps adding some less onerous disclosure obligations? How do you things on trading, things like that? That's the degree of access, I think, is the issue really. The one thing that we haven't talked about too, as well, in terms of the capital markets, is just the view of what this access really, how this access is perceived on Wall Street. I mean, I don't, there aren't, I used to manage brokers at a brokerage firm, and everybody would clamor for IPO, shares of an IPO. You don't see that sort of rancor, that enthusiasm, I guess, on Wall Street with people saying, oh my God, so-and-so in Serbia is doing an ICO on transparency on the private equity market there. Nobody's getting, I don't know, maybe there are some people who are excited about it, but I don't know them.
The junior analysts who are trying to make enough money to quit.
Yeah.
There's a second
And we have time for just two more quick questions. I have two. I see the hand up there. We're gonna start.
You had a question?
Oh, hey, actually, I need to capture the audio, so just hang tight. Thank you.
Thanks so much for all of the sharing. Just going back to, I think, where maybe Stephen started, I think maybe from my perspective, when we think about accessibility and grandmas and taxi drivers, fundamentally for me, it's all about the legitimacy of the issuer. It's not really, I don't care about the Russian guy with the AML. Is the issuer legit? And I think the Journal just had that blockchain ICO article on, they found 25% were just completely fraudulent on these exchanges. So, going back to Law School 101, we learned things like a model UCC, right? And so are there jurisdictions, are there self-policing organizations or exchange collectives that are coming up with an ideal list of kind of fertile soil, that at least eliminates the dumbest things? Like, for example, in California, you don't have to identify who the shareholders are, right? In Hong Kong, the directors, you actually have to have Hong Kong ID numbers or passport numbers. You just have to, otherwise it's a criminal offense in Hong Kong, right? So it's, you know, so I mean, are there simple things, are there certain jurisdictions that are just taking very, very common sense approaches, or are there already that you think, you know, make it less, you know, much more friendly to investors and much more accessible simply because, you know, a lot of the common sense things are just done already?
If I could take the first crack, and then, because I think there is a UCC equivalent for virtual currencies. It's a 2-year project that about, I guess it was October, November, finally came out. A model code to be pushed out to the states for virtual currencies. The way it's written, it would in fact cover ERC-20 type token offerings. I participated in that effort for 2 years. It was not the right time to do it. It's not the right answer for what's going on in the current marketplace, but it's out there now for states to start to, and it is written from a consumer protection perspective. I'll let others address what's going on in sort of the token standard setting area.
There's been talk among some lawyers in the industry whether or not we can reach a consensus and propose to the SEC, let's say a regulation ICO that would put certain rules on an issue, or certain disclosure rules, and then let the token trade as a utility. Whether or not that's going to go anywhere, whether the SEC would take it seriously, or whether or not they'd get a consensus of the lawyers is a good question. I think the SEC would like the industry to do that, and I think a lot of the statements from the SEC has been a kind of disappointment. Like, really, you sold it to these people who, like, you knew were like pumping and dumping it, and why can't you self-police? I mean, kind of the SEC wants us to do their job a little bit, but I hear an argument that the industry should do it. And I think that's one of the ways to do it, because it's hard to police an issuer because the issuer could always just go somewhere else and sell it.
Right. I think maybe there's been less talk about it today because as far as the issuers in the room go, they kind of have an understanding that they're not doing this stuff that's fraudulent, whereas the KYC AML is this big scary thing because you have to check out what other people are doing. But, you know, to answer your question, it's not too unlike the rest of the world. I mean, the Federal Trade Commission, which we kind of glossed over here, has definitely jumped in and is chasing people with, you know, Ponzi schemes, claiming to manage, you know, their various people's tokens. They've gotten some injunctions, so, you know, that's happening. And, you know, that's the same FTC that'll go after somebody for saying that they used Made in America when it wasn't Made in America. So, you know, again, it's a whole bunch of different regulatory regimes and state law regimes. I mean, fraud is still fraud, even if there's not securities involved. You know, at the end of the day, because the tokens are so liquid, it does seem like it has to lead to some kind of public disclosure. And from that perspective, what we've got going in the Securities and Exchange Act may be kind of the right general idea, although I do think a lot of the particular disclosure topics should change to cover something that's more token-oriented than necessarily what we currently have now.
I will add that the Wyoming regulators are actually looking for some answers on this as well. In earnest, they really do want to see internal controls and some supervision of what goes on. I mean, one of the warranties you make if you are seeking utility token status in Wyoming is that you are taking reasonable steps to make sure that that your token is not trading. And what do you do for that? How do you firewall it? What software do you put in place? I mean, they're looking for answers for that.
Yep, and California is doing the same. Bob and I just kind of recently contributed a little bit to, you know, definitions that, you know, are going to be proposed to California legislature. You know, who knows what, you know, what will all happen, but honestly, people are figuring these things out.
And I would estimate, I'm just going through my head, how many different groups are working on some sort of standardization
so many,
processes.
yeah.
And I got up to at least 8 or 9 without having to try very hard, both in the US and internationally.
Excellent. And we are actually out of time for this particular panel, so thank you so much to all of our panelists.